to the next case on this morning's docket. That is case number 110292 in the matter of Ann Gottberg Soderberg.
May it please the court, I am Alexander M. Walczak, Deputy Disciplinary Administrator. Chief Judge Nuss, with the court's permission, I would like to reserve 2 minutes for rebuttal.
2 minutes is granted.
Members of the court, the panel hearing was held in this case in June the 18th, 2003. There were 2 complaints against the respondent. The respondent, in an answer filed the day before the hearing, stipulated to the factual allegations contained in the formal complaint, as well as the 6 violations of the Kansas Rules of Professional Conduct and violation of Supreme Court rules. On review before this court, the respondent elected not to file exceptions to the final hearing report. Accordingly, I believe that the most significant issue before the court today is what is the appropriate discipline in this case. At the panel hearing, I recommended that the appropriate discipline was indefinite suspension from the practice of law. The respondent requested to be placed on probation. The day before the hearing panel, the respondent submitted a cursory petition for a plan of probation. It did not identify any fixes for the problems or cures for the misconduct that was involved in the cases. The panel rejected it for failure to comply with Supreme Court Rule 211G. The hearing panel recommended to this court that the respondent be indefinitely suspended from the practice of law, but that she, rather than wait for the passage of 3 years, any time after she's suspended could apply for reinstatement and appear before a Supreme Court Rule 211 hearing and be required to demonstrate that she made restitution in one of the cases, as well as fixed a quadro in another case, and that she has demonstrated that her mental stability is in order. Before this court today, I'm recommending indefinite suspension from the practice of law because in the 2 complaints, there was financial injury to the clients. The respondent, at least as of this date today, has made no attempts to make any restitution of money in the first complaint, nor fix the quadro in the second complaint, and again, 2 clients were injured, as well as the fact that there was dishonest conduct in misrepresentations to the court which resulted in injury to a client, and thirdly, that because of her prior attorney disciplinary record, she had introduced in evidence were 2 informal admonitions. One was dated 1997, the second one was 2005. On first blush, you may conclude that they were remote. However, if you look further, the 1997 informal admonition has similar type of misconduct as present in this case, as well as that is also at the time that the second complaint began, the events. The events for the second complaint were 1996. Her failure to fix the quadro was 97, 98. An attorney who has been disciplined at that time for lack of diligence, lack of communications, lack of following up on court orders should have been attuned and should have been alert to fulfill that requirements as laid out in the second complaint. The second informal admonition, 2005, also has repeat misconduct, as well as throughout both complaints in this case, the respondent totally ignored repeated requests from the disciplinary administrator upon the docketing of the complaint to provide a response, as well as repeated requests for a response by two different investigators on the two complaints. For these reasons, I'm recommending to the court, or asking the court, to affirm the findings of fact, the conclusions of law, and the recommended discipline of indefinite suspension.
Any questions? Thank you, counsel.
Thank you.
If it please the court, Chief Justice, fellow justices, my name is Michael Stedman. I'm appearing with Ann Soderberg. I have to agree a lot with what our deputy disciplinary prosecutor on this case has stated, that there has been significant impairment on several cases. The two cases in question, though they are not, we don't believe that they're that remote in time. We think the same pattern has been going on for some time with Ann's behavior. We did have testimony regarding this from Dr. Lance Parker. And in mitigation of what can be ordered today, we do want to take into account, and we are asking that the justices look at the facts dealing with her anxiety disorder. And there is some solutions to that. Now, she has been introduced to people from KLAP. Not only Ann McDonald got personally involved in this case, but also members of the Wichita group. Dave Hebert, who has a depressed attorneys group, has taken her to meetings. She has support from that, and she has other female attorneys that have been working with her on that. She has got a personal ride today from a KLAP volunteer from Wichita that was gracious enough to give her support. I think Ann would be the first to say that she's very isolated in her life at this point. She is a perfectionist at work. She's a workaholic. And when she fails to do something, as she did in these two cases, she handles this very poorly and, in fact, has harmed those two clients. And based upon that and all the evidence that was presented and everything else that has been done in this case, the recommendation of suspension, we do agree with at this time. At this time, we believe she is not ready to practice law. But the solutions that are in mind, I think, can change this. And that's why we certainly agree with the recommendation for her ability to apply for reinstatement at a time that is appropriate. It may be a period longer than 3 years, it may be shorter. But she had presented a detailed plan of probation and also a monitoring agreement with KLAP. It cited all of the necessities that happened, and mostly dealing with her anxiety disorder. That has to be something that she deals with and makes a priority in her life, just as if someone was impaired by alcohol or drugs, has to make their recovery number one. Her personal recovery from this, I think, is contingent upon her being able to reapply. But we do have a Dr. Lance Parker who has a great deal of experience in this area and works with other attorneys in our town. She has worked with him in the past, but she will, by her own admission, will state that she hasn't gone to an appointment for several months as she has prepared to wind down her practice. Now, Ms. Soderberg understands she must do both if she plans on doing this. At this point in time, where she is at currently, the recommendations are highly appropriate. There was harm to the public. There was dishonesty to the tribunal. There is nothing in this report that has been overstated. And these are very serious allegations. And these are allegations that I think have been proven at the hearing. And there's restitution that needs to be made because these two human beings that were harmed. One, by failing to file a qualified domestic relations order, and this is back from 1997 when it was actually ordered. That was when, at the completion of the journal entry and decree of divorce after that had been filed. And there was help that was rendered by others. At this point in time, though, the quadro was not complete. And just that in itself, along with the failure to pay restitution of $450, I think definitely warrants the suspension, because at this point in time, the time from filing of the complaints, time from even this case being investigated, she has not taken the necessary steps to reach full recovery from what impairs her with her condition. And I think we had a very good, detailed description of what this anxiety disorder is. But the general public cannot be exposed to that until she has made certain corrections.
Counsel, can I ask a couple of questions here? So we're all agreed that we need to suspend, not only to recognize the discipline, but to protect the public. I also hear you say that there needs to be the possibility of reentry in order to help incentivize that recovery, and I'm okay with that. If we indefinitely suspend, I'm troubled by this indefinite suspension, but it's okay to apply early. And I can't think of when we've done that, and we may have. I just have got to go back, and that was something I kind of went by me, and I need to go look at that. And you might comment on that too. But should we, I think there needs to be a period of suspension that's commensurate with the violations, and I'm not sure yet that's 3 years. And we need to have a 219. So I guess I'm thinking out loud here that with the 219 hearing, can we suspend? What period of time do you think is appropriate to suspend without the possibility of being able to reapply as the discipline, and then figure out how to do this reentry in case that it's appropriate? I'm trying to help. Sometimes we try to help with the recovery in this process, and that's an appropriate part of these proceedings. But I feel a disconnect between what they're arguing and what you're asking for and what the panel seems to be saying, and I can't reconcile that. So what would be your I guess the bottom line is, what would be your recommendation as to a period of suspension that you think is commensurate with the violations?
We are referring to paragraph 69 and 70 that from the final hearing panel, and that's where they made this unique statement in paragraph 70 that she be allowed to apply for reinstatement at any time during the period of suspension. This would require a 219 hearing, and she would have to show that she has done what is necessary to put the people that she harmed back where they should have been originally.
I understand that, but that tells me that we could indefinitely suspend, and that has a definite meaning in terms of what we do, and then she could reapply tomorrow. And I'm not sure those two concepts fit.
I understand.
And so it seems like we need a period of suspension that matches the violations, and that may or may not be 3 years is all I'm telling you. So I'm just asking for your opinion. What do you think should be the discipline of suspension before the reinstatement could be considered, if you have an opinion on that?
I do on that. I believe a minimum time period of at least 12 months would be necessary, and this is based in part that this is a trial lawyer that has 21 years experience, that she has started and began the plan, I think, for her recovery, but she has not followed through. She had so much of her practice that she stated to me that was interfering with that. That tells me that we need some time away from this. But I know that when she was involved in this, she showed a lot of insight into her own behavior. This is a very strong trial lawyer who is very competent in court and has been trying cases. This is a person that loves the law and is a zealous advocate. But her perfectionism, when she fails on something, and she freezes up and she does not deal with it. Even the psychologist that examined her found that it was not a clear case of clinical depression, but rather an anxiety disorder that would lead to this type of behavior. This is correctable. And he had a detailed plan for how to do this, but she needs to dedicate herself to that. And I think at least a minimum period of 12 months before that could even be considered. It may take longer.
In that detailed plan, did it have a timeline?
They referred to perhaps 26 sessions. This is also contingent upon how she was growing during these sessions and what was occurring with her life, and that she had to have full cooperation with KLAP, with everyone else that's working with her, and no hesitation. She needs to get this into her heart. And I believe that at least 12 months is warranted. Longer, because we do know that these are serious allegations, but I believe she has demonstrated that she had made a good beginning. But in order to go forward, even with our probation plan, we had to have that in full effect and demonstrating that we were going through this in an active fashion, all aspects, and that was not demonstrated. That's why probation was not appropriate and knew that. We filed that anyway. It was kind of a guide work for what she can do in the future. You know, demonstrating all these at a 219 hearing by clear and convincing evidence, but not only showing recovery to the victims in this case, but more importantly, in addition, at the end, I think she has to have a full demonstration that she is at a place where she can, through any mental health impairment, competently practice law and not be a danger to any of her clients. But this is a woman that has a great deal of experience and a great deal of compassion for people and is quite capable of doing these things. I think she is still learning her behavior. And this is tough for many attorneys to admit fault, to look into themselves and say, I need to make changes in my life on a daily basis, and then to act on that and actually do the work. She needs time away. That's very important. And we thought it was very compassionate of the panel to recommend this somewhat confusing early before 3 years is up. I was confused by that also, but I think in this individual case with the individual facts, and it may work quite well, and that's why I've recommended all aspects of this report. I thought they did a very detailed, thoughtful, and work that is in the best interests of the citizens of the state of Kansas. But I also think they really showed that they cared about this woman and that she is salvageable, her career is salvageable, and she can be a benefit to our bar. She is one of the stronger trial lawyers I've ever seen in action, and I am very grateful to be able to represent her today. I also know that she is in a lot of pain right now. She's aware of her behavior and how it's harmed others, and she was not raised that way. But I think she needs to balance the fact that she's a human being with that, and she has a problem with that today. She believes she should be perfect in many factors, and when she doesn't live up to that, she freezes and does not take care of her responsibilities. I do want to leave a little bit of time, I know, and would like to at least address the court briefly on this, with your permission.
Please proceed.
Mr. Chief Justice, Justices, thank you for giving me an opportunity to talk today. As I appreciated the ability to talk to the panel and to state what was going on. This is a very difficult time for me, but the good news is that while I owe great apologies to Mrs. Williams and Mr. Williams with regard to the quadro that I did prepare, but it came back with changes, and for some reason it didn't happen. Now, I don't know whether it went to the file, but it just didn't happen. I have pulled that file from the law firm that I used to work for to do the changes. There were 2 modest changes to the order that need to be done. That has been all pulled together and should be reaching Mr. Williams and my client, Ms. Lori Williams, today. Mr. Walker's cases with regards to compensation, I was under the impression that Mr. Walker had been reimbursed all of the fees that he'd paid to my former law firm when that event happened, as I told the panel. And that I had prepared the journal entry, but that he didn't like that journal entry. I think that's a matter of information in the panel's report, one of the findings of fact. However, I have written a check to Mr., and if I said Williams, I didn't mean that, Walker, my apologies. I have written a check to Mr. Walker and sent it off to him.
That's for the full amount of the restitution?
Yes, sir. I do owe them my apologies because it certainly wasn't anything that I intended to do to hurt them in terms of a follow-through. I don't know that anybody can be grateful to be standing here before all of you, but I think the situation has allowed me to address some problems that perhaps I wasn't willing to admit or understand. And so that's good. And I appreciate Mike, and I appreciate Dr. Parker. And I have met with KLAP and those individuals, and they seem very caring and very supportive. In my original meeting with KLAP, one of the things they told me was that I was going to have an obligation to close up my files and get those taken care of, and my clients that were on the books finished and off all of their needs taken care of. So once I got the ruling from the panel, that's where my focus has been, to finish those files, get them out the door to another attorney if possible, or to finish it. And I believe I'm very close to that. And given that a family law lawyer in Wichita, Kansas can sometimes have 50 open files or 70 open files, that has taken all of my energy and all of my effort since the panel's ruling in this particular matter. KLAP also suggested that I go see my medical doctor, and I've done that. One of the things that she mentioned was, talking to the doctor about the fact of my age and my hormones interacting with the anxiety disorder. I don't think that's the problem, but fortunately for me, as a result of going to the doctor, another medical condition came forward and I'm being treated, and so that's a good thing. So if there's gratitude in that regard, I appreciate that. I do intend, when this situation is finished and the files are, and we're almost done closing all of those files. I've not taken any new clients since we were, before we were in Topeka the first time. And so my concentration has been to make sure that the trust of those individuals that I had in terms of open files are being met and being taken care of and processed in an appropriate manner, and I believe that that will be done here shortly. I do appreciate the fact that the panel took into account 20 plus years of practice and my my dedication to my families that I helped and the fact that I enjoyed doing that. That is something that gives me great joy, and I will miss it. But I need to focus in this next year on meeting and getting control of that anxiety disorder if the court allows me to do so. I believe that I have colleagues, both in the local judges who emailed me this morning, other lawyers who have indicated their support to me, and that's another thing that I'm grateful for and have great gratitude as I stand before you this morning. And it gives me the energy and the dedication to, as I've been working on closing the files and meeting the needs of my clients so that those balls are not dropped, that I have an opportunity to go back to do what I love to do, which is to practice family law, which I think any of you who practice family law know it's a unique area of the law. It can be very taxing, but it can also be a very joyful and challenging process, and it's one that I've always enjoyed. I appreciate the fact that the panel seemed to recognize that and were willing to give me the benefit of the doubt and give me an opportunity to work on my own issues and then eventually come back to practice law. I hope that you will support their suggestions here this morning, and I will follow through with Mike's help and the help of KLAP and my friends in Wichita, Kansas. Thank you for taking the time to visit with me this morning.
Any questions of either counsel? All right, thank you.
Thank you. We do appreciate this.
We have reserved 2 minutes for rebuttal.
I want to begin by answering Justice Biles' question. The position of the disciplinary administrator's office is to indefinite suspension, period, and not with the further qualification of early application.
Then make the case that 3 years is the appropriate period of time that she should be away from the practice of law before an attempt to reinstate.
And that's on the basis of there has been no assurances in the past. If you recall, the 2 prior disciplinary administrators, the imposition of informal admonitions, 97 and 205, at that time, that type of dereliction, not responding, 8.1 type of offenses were identified. The respondent was encouraged to seek professional help. There wasn't. The Dr. Parker exhibit, which the respondents refer to, which is Respondent Exhibit B, she only saw Dr. Parker, the psychologist, 1 week prior to the panel hearing. There was no test done, and if you look at the exhibit and if you look at his cross-examination, he only looked at her failure to respond to the docketing of the complaint and not responding to the investigators. He did not look at or even comment on really the significance of the misconduct, and that is not complying with court orders, journal entries, responding to motions, as well as that he had no knowledge of all of her prior attorney discipline and how long this problem went in the past. The description of freezing up, it was only freezing up as to making responses to requests from the disciplinary administrator, not as to the misconduct. Look at disciplinary exhibits 26, 27, and 28, which memorialize the past misconduct, especially number 28, where even on informal admonition, the respondent didn't even show up for a couple scheduled meetings for the imposition. The statements, the factual statements of what the misconduct was in the case is captured in the formal complaint and in the final hearing report as stipulated by the respondent. There was significant misconduct in these 2 cases. There were 3 people injured. There were the 2 in the quadro, both the husband and the former husband, former wife, as well as in the first complaint, one person. For these reasons, again, I'm recommending indefinite suspension. If she feels because I think 3 years is needed to correct the problems fully and have some assurances that she's fit to practice law and she can demonstrate it at that point.
Follow up on Justice Files' question. Have we ever imposed indefinite suspension but allowed a 219 hearing prior to the 3-year period that you can recall, Mr. Walzak?
You know,
It seems to me we have, but
I think there has been one that is back in my mind, but I can't say which case. I'm sorry.
okay, that's fine.
Any more questions? Thank you, counsel. Thank you all for your remarks this morning. The court will take this matter under advisement